My Lords, he says, turning the page, one moment. Yes, I rise to speak to Government Amendment 246E in the name of Baroness Taylor and Lord Grantchester, and also 275A in the name of my noble friend, Lucy. Now I've forgotten her surname. Neville Rolfe, thank you. Good. So I approached this group with the words of the noble Lord Livermore, ringing in my ears from yesterday's oral questions. He boasted how the government's planning reforms would cut away the bureaucracy to get Britain building. Perhaps he was thinking about that other planning bill announced by the Chancellor in August. He couldn't have been thinking about the one before us today, because the combination of Part 3 of this bill, the involvement of Natural England, and the astonishingly long preparation process for EDPs, starting in Clause 58 but going on as far as Clause 61, envisages that it is difficult to see how any mitigation proposal envisaged by Part 3 can be completed in the 3.5 years from now, and for a government that only has 3 3/4 years to run. My Lord, even if Part 3 stands part of this bill at the point of assent, it will take until the next Parliament before someone gets the keys to a new home that has been subject to an EDP. Perhaps someone should tell the noble Lord, Lord Livermore, that Part 3 does not work and it will not get Britain building or the economy growing. And I should know, because I've been in this space for the last 3.5 years as the instigator and a person of significant control in Norfolk Environmental Credits Limited, a company established and owned by all the planning authorities in Norfolk for the benefit of the local councils, taxpayers and economy. My Lords, I know what I'm talking about. This is another one of my specialist subjects. So I observe that Government Amendment 346 is a long one, and I suppose we should be grateful that it recognises that the bill as introduced was deficient. But it is incomplete. It articulates the problem and identifies the EDP participants, but it does not contemplate that the earliest formative stages, the commercial, legal and contractual practicalities to put it into effect. So let's just think about the EDP processes that start in Clause 58. Now, at the outset, it emerged on Monday that Natural England will support a report to MHCLG, Secretary of State's, not DEFRA. Now, that's quite a revelation. What technical knowledge exists in MHCLG to judge the veracity of the poor science and unevidenced assertion referred to by the noble Lord Hunt in today's Daily Telegraph when he said anti-growth environment quangos are blocking developments on spurious grounds? How can MHCLG have the intellect and the capacity to assess this spuriosity? Now, our company in Norfolk aims to go beyond the desirability of cleaning up our rivers to actually devise the commercial models that are legally robust and contractually certain, with a financial system that discounts the 80-year tail liabilities and makes that bridge between those who need to purchase mitigations and those that are prepared to provide it. And I can tell you from personal practical experience how hard this is to devise the system that resuscitates the second largest sector of our local economy, which has been placed into suspended animation for the last 3.5 years, to provide the much needed homes, affordable homes, infrastructure and the mitigation in an area 2/3 of the size of our county. My insight is that before the provisions envisaged by this amendment are engaged, there are some fundamental principles to be established first, and they should be set in statute, and they're not. Now, it's envisaged that the EDPs will issue permits or licences. It's a critical point. Now, a permit is something that is purchased and bought and has asset value. Those of you with long memories will remember the last time the state tried to introduce such permits to solve a problem, and it created the madness of the milk quota system. By contrast, a local authority issuing licences provides for the point at which the mitigation is no longer required because, say, the local sewage treatment plant has been upgraded. And then the licence can be surrendered and issued again with that second slice of revenue returned to the taxpayer. Now, at the drop-in session last week, when Natural England's representatives had blank faces, they did so when I asked them what they planned to sell to developers. Permits or licences? They hadn't got a clue. And that illustrates the intellectual hole in that organisation, because the risk of the permit approach is that once issued to the builder of a new home, the nutrient neutrality permit is attached to that home and goes with the conveyance. That permit will have cost somewhere between £5,000 and £15,000, and that's a pretty powerful incentive for the homeowner to sell it on to someone else. So we find ourselves, as with milk quotas, sleepwalking into creating markets for tradable assets, secondary markets, derivatives, and everything else that history tells us happens when the state gets into the permitting business. The taxpayer misses out, and that's the lesson from the milk quota fiasco. By contrast, a licence is never owned by the developer or the landowner. It doesn't exist as an asset. Contractually, it's tied to the property. It can only be surrendered back to that property. The perverse incentive to sell it on and create secondary markets falls away. And that, my lords, is what we should be doing. But none of this fundamental design principle or parameter is contemplated by either this amendment, 346E, or the bill. And let's move on. Let's think about the longevity of an EDP. It is proposed that an EDP lasts for 10 years, an assertion that has been restated in the letter. I thank the noble baronesses for writing to noble lords this morning. But the tail liabilities for nutrient neutrality are 80 years and 30 years for biodiversity net gain. So I question whether a local planning authority can issue a permission if they're not sure what will happen between years 11 and years 80. I do not believe they can legally issue the permission, and perhaps the noble lady can clarify that. I want to think also about the issue when multiple EDPs, each at a different stage of development, will apply to a proposal. Because I think we heard earlier this week that a single planning proposal could be subject to a layering of EDPs. The clock, or should I say planning bite, will start ticking at the moment Natural England postulates a proposal, but there may be serial clocks running at the same time. And I think this is particularly benighting for small builders, which is why I heartily endorse Amendment 275A in the name of my noble friend, Lady Neville Rolfe. We were told last week that developers will have a choice, and there will be no compulsion to purchase an EDP, and they may purchase other private options. And that's been reiterated today in the letter from the noble baronesses, the ministers, and they make the point that it will be voluntary to buy an EDP from the state, unless it's compulsory, in which case there will be no choice as well. And so there are powers in the bill to force a developer to use an EDP in certain circumstances, no matter how expensive it is, no matter how far away it is, and however long it takes to produce. There will be a choice for these small developers. It's Hobson's choice, and that's no good. I'm concerned for what is becoming quite a dynamic and well-developed private industry that is innovating and being creative in the provision of mitigations. Previously, the noble lady, the minister, smirked when I said, well, the bill with all its monopoly regulator and supplier functions meant that Natural England effectively nationalised nature. I don't see anybody laughing now, because that's what we're sleepwalking into. So we could end up with a situation where a developer may need to pay twice for his mitigation. Once for a private scheme close at hand that is acceptable to local people and the planning authority, and again because it's compulsory to purchase another one miles away. But whichever option is chosen, the very act of triggering the EDP process effectively sterilises that proposal and makes it harder to get Britain building. Now, time is limited, so there are many more fundamental design questions and processes I could ask before we even get to the start line. And it would have been much more helpful, in my view, and I thank the noble Lord Krebs for his detailed diagram, which has been circulated this morning. That diagram would have been much better had there been a timeline that exists before then, because it assumes the EDP is existing. My lords, I think, as my noble friend Lord Lucas has said, it's probably at least 3.5, possibly as many as 5 years, till we actually get to that start line. And I think, noble lords, we need to understand that. Now, on Monday, the noble Lord Russell asked us, well, why are we doing this? What is the purpose? And it seems to me that the purpose of Part 3 isn't to clean up nature. It isn't to get Britain building. It's simply to puff up an anti-growth quango, giving them a super veto over developments in a significant proportion of our nation for no other purpose than to build a bureaucracy that gets in the way of growth and makes it harder to generate the taxes for public services and is so expensive to the developer that the pursuance of other important pieces of infrastructure like social housing are crowded out. It's still not too late to excise Part 3 from the record, and with only 4 days allocated in report in October, that would make our job much easier. But I think the assertion yesterday at the dispatch box by Lord Livermore that this planning reform was going to speed up building is a confidence trick. So I welcome 346E as far as it goes, but it needs to go much further in contemplating the how, as well as the what, if we're not to stymie growth until the next Parliament.